Hi everyone, let's talk about criminal law and business. In this lesson, we'll define what a crime is, describing the essential elements. We'll describe criminal procedure, including arrest, indictment, and arraignment. We'll describe a criminal trial and the standard of proof that must be met to find a person guilty of a crime. We'll describe common crimes such as murder, robbery, and larceny. We'll identify and describe businesses and white-collar crimes. We'll list and describe some cyber crimes, and we'll explain various constitutional protections regarding criminal law. So to start off with, defining a crime, well, it's an act done by an individual that is in violation of the duties that he or she owes to society, and is also the violation is something that the law provides that the wrongdoer shall make amends to the public for. So I've done something that is against some law, violating some duty that I owe to the society, and that I'm going to owe something back to society, whether that be fines or imprisonment or whatever the thing might be. So in the U.S. criminal law system, a person accused of a crime is presumed to be innocent until they are proven guilty. That's pretty huge because not every country works that way. There are some places in which you are presumed to be guilty unless you can prove your innocence, which is much harder. The burden of proof is on the government to prove that the accused person committed the crime. The accused person must be found guilty beyond a reasonable doubt, which is different than the standard of proof for a civil trial, which is based on a preponderance of the evidence. This is a much higher standard of proof here for criminal law, beyond a reasonable doubt. The conviction requires a unanimous jury vote to convict somebody of a crime, meaning every jury has to vote in favor of the conviction. The accused is provided with constitutional safeguards during the criminal justice process. So the main source of criminal law are the criminal statutes. There are federal and state criminal statutes. States have adopted comprehensive penal codes. A penal code is just a collection of all the criminal statutes for that state. It defines activities that are considered to be crimes, and it establishes penalties imposed for their commission. North Carolina has a specific punishment chart that defines the level of felony or level of misdemeanor, and then gives ranges for punishment, prison sentences, basically. You can click that link and look up those charts just to see sort of the ranges. I think they're expressed in terms of the months that you're allowed to sentence somebody for. But yeah, you can look that up if you're interested, just to see what's there. The Federal Criminal Code defines federal crimes, of course. And then finally, there are regulatory statutes which exist at both the state and federal level regarding environmental laws, security laws, antitrust laws. Whatever the regulatory framework is will have certain laws in place, and there might be criminal penalties for violating those laws, just depending on what the regulatory framework is. So the penalties for crimes can include various things. It could be simply the imposition of a fine. It could be community service, probation, imprisonment, and then sometimes other forms of punishment, just sort of depending on the nature of the crime. The absolute worst penalty possible is the death penalty, which is still legal in the United States. Some other countries have made it illegal. Some states in the United States have made the death penalty illegal, but not North Carolina. So we'll just sort of see what happens there. But that's restricted to one specific type of crime that we'll look at in a little bit, first-degree murder. Imprisonment is imposed too, and sort of looking at the reasons or the justifications for imprisonment. One is to incapacitate the criminal, basically get them off the streets. If they're judged to be a dangerous person that shouldn't be out in society, we lock them away. Providing rehabilitation, a lot of debate surrounding that, whether or not prison is actually an environment where rehabilitation can happen. But that's at least one of the theories, is you provide some services to get the person to give up the life of crime and re-enter society as a productive member of society. Again, you can make up your own mind on how effective rehabilitation is in our prison system. Offering prison sentences is also supposed to deter others from similar conduct. Again, debatable whether or not that actually happens. I know that I don't particularly want to go to prison, so there's lots of things that I'm just not going to do because I'm not going to risk it. And then one thing that people don't think about a lot of time is inhibiting personal retribution by the victim. So, and we can see a lot of this these days where if people don't feel as though justice has been served, things can get a little tricky, where victims of crimes or their families might go after a person, or if they feel like in this environment right now, we're going through the COVID crisis, and there's also been some very unfortunate deaths at the hands of police, and a lot of people are very frustrated and angry and are expressing that in the forms of protests, and then sometimes even through violence, but mostly peaceful protests. If we take away justice and if people don't feel like they're getting justice, then it can lead to a pretty tricky environment. So if they feel that justice has been served, then people are much less likely to pursue their own retribution or acting out on their own. Since this is a business law class, we should take a second to just recognize that I can't imprison a business. It's an artificial person. It doesn't exist as something that we can actually put into prison. But the people that are involved in the business can be imprisoned, including the owners, the officers, board of directors, employees. Depending on what has been done by those people, they potentially could be imprisoned. Businesses, however, can be held vicariously liable for the actions of their agents or employees. What that means is if you have somebody acting on behalf of a business, could be an employee, could be just some other agent. If they do something criminally wrong, then as long as they're acting within the scope of their employment and as long as they're involved in doing business stuff at the time that they commit the crime, then we can actually hold the business criminally liable for those actions. So very important to make sure we're training our employees well, making sure that they are being supervised properly, to try to at least avoid some vicarious liability down the road. So we can't throw them in prison. We can't throw a business in prison, rather. But what can we do? Well, businesses can be fined. A court could compel a business to do certain things. A court could enjoin or stop a business from doing certain things. Worst case scenario for a business would be that they lose their license or their charter, meaning that they no longer have the right to exist as a business anymore, forcing them out of business. So the parties to a criminal action. We're going to take this step by step and just take every little piece apart here. Just keep in mind that criminal law is a huge area of law, and we're just sort of skimming the surface. So we'll do the best we can, and I think we'll learn a lot along the way. The parties to the criminal action. Okay, the plaintiff in a criminal action is going to be the government. This is going to be a prosecuting attorney that's going to be trying the case. Or maybe a district attorney that can be called various things, but it oftentimes is expressed as maybe North Carolina versus some person, or the United States of America versus some person. So the government is the plaintiff. The defendant is the person accused of a crime. The government's going to be represented by a prosecutor. The accused is going to be represented by a defense attorney. If a defendant can't afford a private attorney, the government will provide one. This provided defense attorney is called a public defender. This has been interpreted out of our constitutional rights, the right to have representation and defense to a criminal trial. So we can take crimes and break them up into various categories, the most serious being a felony, usually punishable by imprisonment for a year or more. Less serious than a felony would be a misdemeanor, usually punishable by fines or imprisonment for less than a year. Below that, we have violations that are considered to be the least serious of crimes, usually punishable by a fine, sometimes by imprisonment for a few days, not very long. We can also break them into categories of intent and non-intent crimes. So for an intent crime, I have to prove two elements. One is the criminal act, or the actus reus, and then the criminal intent, or the mens rea. But the criminal act is obviously the act or omission, whatever the thing is that would give rise to at least the thought of a criminal act having happened. Second, the criminal intent means I have to have some requisite state of mind. If it's a specific intent crime, I committed the crime with a specific outcome in mind. It could be that I intend to kill somebody, so I form a plan and then I take actions to kill a person, knowing that that outcome is going to result. Then I could also have a general intent crime, which is I don't necessarily have a specific outcome in mind, but I know, or at least I should know, that some harm could occur. And so a lot of times people throw something like assault into the general intent crime, where if I'm particularly upset with somebody and I fling myself at them and try to attack them, I'm not sure what will happen, but I'm pretty sure that some harm could occur through that action. Merely thinking about a crime is not a crime because no action has been taken. Although, having said that, if I take specific actions to plan out a crime, sometimes that can put me in the realm of criminal conspiracy, which actually is a crime. Non-intent crimes, they impose criminal liability without a finding of intent. These are imposed for reckless or grossly negligent conduct that could cause injury to another person. Involuntary manslaughter is an example of a non-intent crime where I've done something. Let's say I'm driving and I'm looking at my phone at the same time, trying to do a text message or something. That's very reckless behavior. And let's say somebody's trying to cross the road and I run over them and they die. Obviously, I didn't intend for that to happen. I didn't mean to kill anybody, but it happened regardless, and it happened because of my reckless or negligent conduct. So they wouldn't have to prove that I intended for that outcome to happen. They would just have to show that I was acting recklessly or negligently, and that harm occurred. So, to be arrested, police have to obtain they usually have to obtain an arrest warrant based on a showing of probable cause. Probable cause is the substantial likelihood that a person either committed or is about to commit a crime. Warrantless arrests can also happen. This is when police arrive during the commission of a crime, when a person is fleeing from the scene of a crime, or in a situation where police judge that evidence is likely to be destroyed. So you don't always have an arrest warrant, but if police are planning out an arrest ahead of time, they do need to obtain a warrant. So there you go. Booking is the administrative procedure for recording an arrest and collecting other information from the suspect. So we can bring about formal charges by either an indictment or an information. An indictment is for serious crimes. It's a charge for having committed a crime based on the judgment of a grand jury. A grand jury is a group of people that we get together. The prosecutor will present the evidence that they have before the grand jury and then give the grand jury, the opportunity to decide whether or not they think the government has enough information or enough evidence to justify bringing criminal charges. And if they think so, they issue the indictment, and that person can be charged. If the grand jury doesn't think there's enough information, then the charges will be dismissed. An information is for less serious crimes. It's a charge based on the judgment of a magistrate. A magistrate deals with accusations or people accused of lesser crimes. They'll be the person that determines whether or not there's enough evidence in issuing that information statement. The arraignment is the proceeding during which the accused person is informed of all the charges against them, and they're asked to enter a plea. That plea usually takes the form of either guilty or not guilty, although there is an additional plea usually called nolo. The long name is nolo contendere. What nolo contendere means is that a person does not admit guilt, but they agree to a penalty. Usually the judge has to agree to even accept this kind of plea. And there probably is going to be some kind of negotiation maybe between the prosecutor and the defendant regarding what kind of penalty will be imposed. This does happen a lot with businesses, especially when the business does not want to admit any guilt, but the government's not going to drop the charges. So what they might do is just enter into some kind of negotiation where the business has to pay the government X amount of dollars as a penalty. The business will be allowed to plead nolo, not admitting guilt, but just going ahead to pay the penalty to make the charges, or at least to settle the charges. Once we plead nolo, pay the penalty, then we can't use that as evidence of liability against the accused at subsequent civil trials. So that's why it happens a lot of the time, is because a business doesn't want to plead guilty because that might open them up to further liability later on down the road. A plea bargain is a negotiation prior to a trial with the intent of trying to avoid trial. So the two parties have different motivations for plea bargaining. For the state, they want to save time, save money, and maybe just make the court docket a little bit less full. From the defendant's perspective, they might be facing a lot of charges that carry a lot of prison time, and so their motivation to plea might be to plead down to a lesser charge, to a lesser prison sentence than if they were found to be guilty. If you research plea bargaining and the way it happens, the vast majority of cases are plea bargained and don't actually go to trial. There's some amount of controversy surrounding that and whether or not that's fair to defendants, whether or not it's a good thing for society overall. I'm not going to tell you what to think. You can form your own opinion based on your research. But that's what plea bargaining is. The government will usually agree to impose a lesser sentence than might have been obtained. Maybe they only charge them with one charge versus 10, or maybe they back down a felony down to a misdemeanor or something like that, to try to bargain and settle that charge without actually having to go to trial. In a criminal trial, in order for a person to be convicted of a crime, the verdict has to be unanimous, meaning every juror has to vote in favor of conviction. If even one juror disagrees and won't vote in favor, then the person is not found to be guilty of the crime. So basically three things can happen. One is that we have unanimous vote in favor, meaning the person is convicted of the crime. Second, we could have unanimous vote against, meaning the person is found to be not guilty. And then three, if we don't have a unanimous vote, then we have a hung jury, which is a jury that can't come to a unanimous decision. If a person is found to be guilty, the defendant does have the right to appeal that conviction to a higher court, if the higher court accepts that appeal. If the defendant is found to be not guilty, in other words, if there's a unanimous vote against their guilt, the government cannot appeal because that would violate the double jeopardy clause of the United States Constitution. However, if there's a hung jury, the government may choose to retry the case before a new judge or jury. Now, some people think that that is also double jeopardy, and you might be right. You know, it's just one quirk of our law. But in a legal sense, the way that the courts have interpreted it so far in the United States, if a hung jury results and if the government chooses to retry, then it's not a violation of double jeopardy. So Maryland versus Kulbicki deals with an appeal of a criminal conviction. So Kulbicki was found guilty of murdering his girlfriend by shooting her in the head. During the original trial, the state used ballistics analysis, analyzing some of the bullets that were found in his truck with the one that killed his girlfriend. So he went to prison, having been found guilty. 11 years later, a new method of analyzing ballistics came out, and he appealed on the grounds that his counsel was unreasonably ineffective in representing him. So he actually won in an appellate court, which said that he needed to be retried, and it got appealed to the United States Supreme Court, which said that the appellate court actually should not have requested or at least ordered the new trial, because they were using a standard which would have required him to have basically perfect advocacy by his counsel. But that's not what the Constitution guarantees anybody. The interpretation currently just being that a person should have representation that's at least reasonably adequate. And he did have reasonably adequate representation during the original trial. The fact that they could have chosen a different strategy, looking back, and that different strategy might have been better, wasn't enough to overturn his conviction. So his conviction stood. So now we're going to look at some common crimes. And the first one that a lot of people think about is murder. This is the unlawful killing of a human being by another person. Even calling it murder has a specific connotation, because the word murder is usually reserved for what we call first-degree murder, which would be the most serious kind, which could potentially carry the death penalty with it. It's usually more accurate to call a killing homicide, which can involve multiple different levels. So murder can have, of course, depending on the circumstances, different levels that can carry with it different penalties. You can even back it down into involuntary or voluntary manslaughter, which would be even less serious. But one thing, most people are aware of those things. One thing that people might not be aware of, or at least commonly aren't aware of, is the felony murder rule. And what this is, it says that a murder committed during the commission of any felony may be prosecuted as murder. And we infer the intent to commit murder from the intent to commit another crime. So what does this mean? It means that, let's say I'm hard up for money and I'm going to break into somebody else's house and steal whatever money they have. But during that, my intent at the time is just to break into somebody's house and steal money. But during that time, let's say that the homeowner awakes and challenges me, and I end up killing that person. Or maybe even I don't kill the person, maybe my accomplice kills the person. Since I was already in the commission of another crime, if another person dies as a result, I could potentially be charged with murder because of that felony murder rule. So this one gets a lot of people who aren't aware of how serious their actions can be if a person dies or is killed while they're committing some other crime. If you are looking at the slideshow, you can see links to the definition of murder in North Carolina. There's even a link to another case, which was kind of a new thing at the time, but it was basically considering whether or not somebody could be charged with manslaughter for encouraging another person to commit suicide. Basically had a boyfriend who had some bouts of depression and had threatened suicide before in the past, and he was texting with his girlfriend, and she was basically just telling him to go ahead and do it, that he should go ahead and kill himself. He ended up actually committing suicide, and later she was brought up on charges of manslaughter for encouraging it. I don't know if that kind of thing had ever been tried before, but she actually had, she was found to be guilty of manslaughter and served a prison sentence. I think she was sentenced to maybe 4 or 5 years. I think she maybe only served 1 and then got out on good behavior. But that is a possibility. So now we'll talk about some other common crimes. A lot of people get confused with robbery, burglary, and larceny, and aren't really sure which one is which. So we'll take time just to sort of separate them out a little bit. Robbery is the taking of personal property from another person by the use of fear or force. If I use a weapon, it's considered to be armed or aggravated robbery, which would carry a much higher penalty. So I'm taking somebody from another person while they're there by using fear or force. Burglary is taking a personal property from another person's home, office, or commercial or other type of building. Usually requires that I'm entering a place that I'm not supposed to be and taking things from there. The other person doesn't need to be there. I'm not using fear or force because that person's, I haven't been confronted by that person. So when a lot of people say they've been robbed, they've actually been burgled. And then finally we have larceny, which is the wrongful or fraudulent taking of another person's personal property. It doesn't require that I enter a place that I'm not supposed to be, doesn't require force, fear, doesn't require that I've forced my way into a structure where I'm not supposed to be. And then most states distinguish between grand or petite larceny or petty larceny would be how people say it more often now. But it would be based on the value of property taken. So usually something like $1,000 or something like that would separate grand from petty larceny. Grand larceny would carry a heavier penalty than petty larceny. Receiving stolen property is a crime. If I know that somebody has stolen property and I just buy it from them or they give it to me, that is its own separate crime. It does require that I know that the property was stolen. If I don't know, then I wouldn't be found guilty. Arson is the malicious or willful burning of another dwelling. The latest law applies to the burning of all types of structures. It includes willful burning by the structure's owner. So, you know, even if I'm burning down my own building, if I've done it on purpose, I could be found guilty of arson. Forgery is the fraudulent making or alteration of a written document that affects the legal liability of another person. Usually, it could be signing another person's name to a document. It could be, well, a lot of times this happens with something like checks, where somebody gets a hold of somebody else's checkbook and they start writing checks, signing their name to it. It could also be that if a person has already signed a check, I get a hold of it and then change the dollar amount. Then that would also be forgery because I'm making an alteration that I'm not authorized to make, and that would affect the legal liability of the other person. A lot of these crimes are called white-collar crimes because they're often committed by business people or white-collar workers. There's a lot of criticism of the U.S. legal system saying that we treat white-collar crimes as being much less serious than other types of crimes. And again, there is probably some legitimacy to that, but I won't try to tell you what to think. You can make up your own mind. Embezzlement is one of these white-collar crimes, which is the fraudulent conversion of property by a person to whom that property was entrusted. Conversion is a legal term for saying that I've taken something and made it mine when it wasn't mine rightfully. Usually we're talking about a person who works for a business who's stealing the business's money, making it their own when they don't have the right to that money. Bribery is a crime in which one person gives another person something of value for a favor in return. A lot of times when you hear about bribery, you're talking about a public official. It could be a police officer or a congressperson or something like that, where somebody's offering them money to do something they otherwise would not do in that quid pro quo type fashion. There's a lot of debate about whether or not somebody giving money to somebody's campaign, these campaign contribution type things where that person expects special access to a politician, whether or not that should be considered bribery. Right now it's not. But if you can prove that a person offered, let's say a senator or a representative, some amount of money that in order that they take some specific action, if you can show the tie between this amount of money and this specific action, then you can show bribery. If you take it more in the business context, the one thing that's a little bit, I guess maybe a little bit controversial, is the United States has a law saying that United States businesses can't offer bribes in foreign countries. So if you're trying to do business in a foreign country, you might go over there and find out that their government is not as stable or not as legit as ours is. And in order to get business done, a lot of the officials over there expect bribes in order to sort of grease the wheels and get things moving. And according to U.S. law, U.S. businesses are forbidden from doing that in foreign countries. I know President Trump has tried to advocate for taking away that, saying that it sort of handcuffs our business. My personal opinion, it's maybe not that good of an idea to allow businesses to offer bribes. Again, you can make up your own mind on that one. Moving on, extortion is obtaining property from another person with that person's consent, but having been induced by the wrongful threat to injure the victim's person, their property, or reputation. Classic case of extortion, usually think of mob tactics where, a mob member goes around to a business and says that the business owes the mob member a protection fee of $500 a month, or else the mob member might burn down their business or something like that. That would be obtaining or money from a person with their consent, but having used a wrongful threat in order to obtain it. So that's extortion. Blackmail is a common term for extortion of a private person. You hear about this sometimes where maybe a person found compromising photos of a celebrity or something like that, and they go to that celebrity and they say, you need to pay me $1 million or else I'm going to make these photos public and show everybody what you've been doing. That would be illegal, considered extortion, common term for it, since it's a private person, being blackmail. It's just a version of extortion. Criminal fraud is obtaining title to property through deception or trickery, also called obtaining property by false pretenses, which is what is called in North Carolina, or deceit. It can also include separate charges of mail fraud and wire fraud, which are specific statutes saying that if I commit fraud using the mail services, which would be the U.S. Post Office or UPS or FedEx, or if I'm using wires like telecommunications, telephone, internet, to commit fraud, I can add a separate charge on there. And sometimes mail fraud and wire fraud are tacked on just because it might be easier to convict somebody of those rather than convicting them on other types of fraud. If you see the purple links throughout the presentation when you're looking at it, that means there's a link to North Carolina's definition and version in the statutes of that. So if you're looking at the PowerPoint, you can click on those to see the North Carolina specific version and definitions of those crimes. Money laundering is, quote, washing money from illegal activities to make it look like it was earned legitimately. So if I'm earning a whole lot of money through illegal acts, eventually I could run into a real issue where it's going to be hard for me to actually spend any of that money, because then banks or the government is going to wonder where that money came from. And if they find out that it came from illegal activities, then I'm in big trouble. So I might try to maybe set up a business and then run the illegal money through that legitimate business to try to make it look like the money is actually legitimate. And then I could deposit it into a bank. I could go out and spend large amounts of money without a bunch of government interference. So that's what money laundering is. Under the Money Laundering Control Act, it is a crime to knowingly engage in monetary transactions through financial institutions involving property from unlawful activity worth more than $10,000. If any of you are familiar with handling large amounts of money, maybe you're in charge of making deposits for a business you work for or something like that, you know that if you make a deposit at your bank for $10,000 or more, there's some extra paperwork you have to fill out. The government's going to be notified of that transaction, so they can sort of keep track of where money is flowing. There's actually a separate charge, so somebody, if they're trying to avoid that extra paperwork, they might take the money and break it up into smaller deposits and then deposit $9,000 instead of $10,000 and just deposit $9,000 a bunch of times. That's a separate charge called structuring to try to avoid the government scrutiny, and that's something that people can actually get in trouble for there too. So you got to be careful with that kind of thing. If I knowingly engage in a financial transaction involving proceeds of illegal activity that can wrap me up into money laundering, if I'm convicted, I can face fines of up to $500,000 or twice the value of whatever the property is, whichever is greater. I can also be sentenced to up to 20 years in federal prison under the Federal Money Laundering Control Act. And then most states also have separate money laundering statutes that I could also be convicted of. RICO, the Racketeer Influenced and Corrupt Organizations Act. This was passed many years ago in an attempt to try to rein in organized crime, the mafia, in other words. And it was pretty successful in allowing the government to pursue these organized crime organizations and take away at least some of their power. Over time, RICO, since it's a law on the books and it's not reserved solely for the mob, can be used against other organizations. Sometimes even businesses can get wrapped up into RICO charges. Some attorneys have sort of latched onto that to the point where we even had to go in and sort of modify some of the RICO laws to make sure that people aren't abusing them just to try to get more money. But we can have criminal and civil charges under RICO. If you go through and read the statutes, it basically just sets out a bunch of different racketeering type activities that would fall under them that you can be legally liable for. And then North Carolina, at the link at the bottom, has its own separate RICO Act. Criminal conspiracy is when two or more persons enter into an agreement to commit a crime. So we mentioned earlier in the presentation that I can't be convicted for just thinking about committing a crime. However, if I am actually taking steps to plan out that crime, then that can get me involved in criminal conspiracy, which I can be convicted of. So to be liable for this, the persons involved have to intend to commit an overt act to further the crime. The crime does not actually have to be committed. So this has gotten some people before they were able to actually commit a crime. If somebody was planning to bomb some building and we can show that they had bought the materials and started constructing bombs and they had plans to go bomb a building, then even though they haven't actually committed that act yet, since they're conspiring to commit the act, then you can get them on that charge. So switching gears a little bit here, we'll talk about cyber crimes, and we'll look at some legislation that was passed to try to address some of the cyber crimes. Cybercrime, the definition can change, or the name can change over time. I guess the idea would be that we basically just make them normal crimes. as the internet and computers were on the rise, we carved out specific names for them, cyber this or that. Give it a few more years and it'll just be criminal law just like any others. But we do have some federal laws that we'll talk about. One is the Information Infrastructure Protection Act, which is a federal act that makes it a crime for anyone to access and acquire information intentionally from a protected computer without authorization. The Counterfeit Access Device and Computer Fraud and Abuse Act, or CFAA, makes it a federal crime to use a computer knowingly to obtain restricted federal government information, financial records of financial institutions, consumer reports of consumer reporting agencies. In United States versus Barrington, we have a case of one student, Barrington, plus several accomplices who had figured out how to hack their university's grading system and change grades. So I think by the time they got caught, they had probably changed the grades of upwards of 90 students before a professor sort of figured out what was going on and got the FBI involved. So his accomplices all pled out and got just under 2-year prison sentences. Barrington went all the way to trial. One of his accomplices testified against him, and he ended up getting sentenced to 7 years in prison, which he appealed, saying it was too serious of a sentence and it should be reduced. But at the United States Court of Appeals for the 11th Circuit, the court found that given there was plenty of evidence that he had actually committed the crime, and given his behavior during the trial, including lying and trying to cover up things, and basically just disregard for the law, they upheld the sentence. And so the 7-year prison sentence stood. The crime they accused him of here was wire fraud. Now we start looking into some constitutional protections for people. The Fourth Amendment to the United States Constitution protects persons and corporations from overzealous investigative activities by the government, saying that the government, if it's going to search through your things, if it's going to seize your things, it has to have a reasonable grounds in order to do so. So if there is a reasonable search and seizure by the government, that is completely lawful. But they usually have to have some basis for believing that some illegal activity is going on, and they usually have to have a warrant. So a search warrant is based on probable cause and is necessary in most cases. Not all cases. There are some instances in which a warrantless search or seizure can happen. But since we're talking about business law here, usually a government can't search a business without a search warrant. That warrant will define the scope of how far they can go in the search, what specifically they're searching for, just so they can't rifle through everything looking for anything. In Birchfield versus North Dakota, we had the Supreme Court considering whether or not breath or blood tests for a suspected drunk driver violate the Fourth Amendment. So in these states, and in a lot of states, if you're pulled over under suspicion of being drunk while driving, they can ask you to submit to breathalyzer or breath test, or maybe even a blood test to see what your blood alcohol level is. And if you refuse the tests, there are some criminal charges or some violations that can apply. Oftentimes it takes the form of something like suspension of your driver's license for a specific amount of time. It might even carry a prison sentence if you refuse the tests. So some drivers that were pulled over and refused the tests and faced these criminal violations sued, saying that they were a violation of the Fourth Amendment. So while the Supreme Court was considering it, they said that the breath test is not very invasive, so it's not a violation of the Fourth Amendment, but extracting blood from a person is much more invasive. So if the state was going to conduct a blood test, they needed to get a warrant first. So those implied consent laws saying that if you refuse the test, you face these violations automatically could apply toward the breath test, but not to the blood test. So along the lines of unreasonable search and seizure, the exclusionary rule says that if evidence is obtained from an unreasonable search and seizure, it is prohibited from introduction at a trial or proceeding against that person. The thought process being here that if evidence is obtained illegally through an unreasonable search or seizure, that evidence is tainted, and thus anything that I uncover is fruit of the tainted tree and can't be used. However, the courts have carved out a narrow exception called the good faith exception, saying that evidence may be introduced if law enforcement at the time reasonably believed that they were acting pursuant to a lawful search warrant. In the case of Riley versus California, the Supreme Court had to consider whether or not police had to obtain a warrant to search through somebody's cell phone. And through analyzing this, well, the case involved a guy that was pulled over. They searched through his phone, and then they found photos that seemed to incriminate him in some crimes that they were actually searching for suspects for. But then the question arose, can police search through your cell phone without your consent or without a warrant? And ultimately what the Supreme Court found is that our cell phones are a little bit unlike our wallets or the other things that we might carry around us, in that they contain so much information about a person that if a police officer is going to search through them, they really do need to get a warrant first. The Fifth Amendment, you'll hear about a lot, or at least you hear about a lot on TV when somebody pleads the Fifth. But it's the amendment that states that a person can't be compelled to be a witness against himself or herself in a criminal case. So having said that, non-testimonial evidence, including fingerprints or body fluids, can be obtained without being a violation of the Fifth Amendment. And the Fifth Amendment only protects natural persons, you and I, natural persons who are accused of crimes. Businesses are considered to be artificial persons, so a business in and of itself does not have the right to plead the Fifth Amendment. They can be compelled to turn over information that might be incriminating against themselves. Miranda rights are the rights that a suspect must be informed of before being interrogated by police. It ensures that a suspect does not unwittingly give up his or her Fifth Amendment right. So the forms that Miranda rights can take and what police say can vary, but they all revolve around the central themes of a person having the right to remain silent, the things that they say can and will be used against them, that they have the right to consult a lawyer and to have a lawyer present during questioning, and if that they can't afford a lawyer will be appointed to them free of charge. So what the police officers say can vary in the specific wording, but they're all going to contain these four elements in them. So some information is privileged from coming out in court or from somebody being forced to reveal that information. So and different relationships can carry with it different privileges. So one of these special privileges is between an attorney and their client. So a client can tell their attorney things without fear that the attorney will be called on as a witness against them, revealing that information. Other privileges that exist are between a psychiatrist or a psychologist and their patient, between a priest or a minister or a rabbi or an imam against their the person that they're serving. against a spouse can't be called and forced to testify against their spouse. And a parent can't be forced to testify against their child, or a child forced to testify against their parent. However, there is no accountant-client privilege under federal law, so an accountant can be called as a witness in cases involving federal crimes. Things that have come up recently about this kind of thing are there are several people who are trying to charge President Trump with various crimes. And what he was claiming, and what the government was claiming a lot of the time, was that there was attorney-client privilege between him and either Michael Cohen or maybe Rudy Giuliani, saying that certain information couldn't be compelled to come out in court, sort of testing the boundaries of that. And then some other people are actually trying to go after some financial records that are held at various banks, and the presidential administration is trying to keep that information from coming out, sort of testing the boundaries of what information can we actually access about a president. Does a president have any special immunities or special privileges as being the president of the United States that would protect certain information about them? And if they do have those protections, do they exist only while that person is president? Sort of opening the question of, well, what if they're when they're not president anymore? Can that information come out? And I don't know what's going to happen. I guess we'll just have to sort of wait and see. So sometimes when a government is trying to bring criminal charges, they might bring in another person who maybe they're not targeting specifically, but that they think might have some information that they might help them get the person they actually want. And so sometimes what they might offer that person to convince them to actually testify against their actual target, they might offer them immunity from prosecution in exchange for their testimony. So if that person agrees to testify against the actual target of the investigation or the target of the charges, then they would be given some form of immunity. It might be blanket immunity, it might be very specific immunity for certain things, but they might get immunity from facing criminal charges themselves. In exchange for that. Once a person has been granted that immunity, they then lose the right to assert their Fifth Amendment privilege. Since they can't be criminally charged anyway, then they could testify about their own criminal activities in the process of testifying against the target of the criminal charges. Some other constitutional protections are the protection against double jeopardy, the Fifth Amendment providing that a person can't be tried twice for the same crime. It's not always so easy to define. We talked earlier about if a person is found to be not guilty by a jury, then they can't be tried again. But if the result is a hung jury, then they possibly actually could be tried again. So double jeopardy is not quite as clear-cut as a lot of people might think it is, but it does provide, if a jury finds me to be not guilty, then I can't be tried again for the same thing. The Sixth Amendment guarantees that a criminal defendant will be tried by an impartial jury of the state or district in which the alleged crime was committed. Jury trials were designed to try to prevent if there's a biased judge or maybe a corrupt judge, or at least accusations of a judge being corrupt, then we could bring in a jury of my own peers, usually from the same place where I'm from, hopefully even composed of the same kind of people that I'm from. And then that jury would then have the ultimate say over whether or not I'm guilty or going to be convicted of that crime. I have the right to confront or in other words, cross-examine the witnesses who are testifying against me. If they get up and testify against me, I have the ability, and it's probably not going to be me, it's probably going to be my attorney, who's going to cross-examine them and challenge their testimony. I have the right to have the assistance of a lawyer. If I can't afford one, then the state will appoint one for me, and I have the right to a speedy trial. the definition of speedy trial can be quite flexible. It still can take a year or even years to get through a trial. The Eighth Amendment protects criminals from torture or other abusive forms of punishment. Our definitions of cruel and unusual have changed over time and most likely will continue to change over time according to the standards in existence at that time. So right now, there are some countries who have outright banned capital punishment or the death penalty, saying that it's just inherently cruel and unusual. The United States has not taken that stance, so it would go state by state as to whether or not the death penalty is allowed. And there have been a lot of recent cases where a state is trying to execute somebody, but they're having a hard time obtaining the materials required to do so. So one of the most commonly accepted forms of the death penalty in the United States is lethal injection, which has been viewed as one of the more humane ways to kill a person. But then we found out that a lot of the places that are making those chemicals involved in the lethal injection were refusing to sell them to the United States because they knew that they were going to be used for lethal injection. So there were cases recently where I think the state of Oklahoma had a really hard time trying to obtain certain chemicals, so they used alternatives, and it just turned out to be kind of a botched execution. There have been some places that are trying to bring back the electric chair or bring back the firing squad as a method for executing convicted criminals. Time will tell where we go with this, where our attitudes as a society lie regarding the appropriateness of the death penalty as a punishment, whether or not it sticks around or if it goes away. Some people say that solitary confinement in a prison system is cruel and unusual. Right now, it's not been ruled that way by any court, so it still can be used. But again, over time, we might judge that different things are cruel and unusual just based on the norms of society at that time. So that wraps us up for this lesson. I hope this is helpful to everybody. If you have questions, reach out. Otherwise, have a great day.